Correctional Services Commissioner Arthur Fraser overruled a recommendation that Zuma should not be granted medical parole. Fraser made this startling admission in an SABC interview last night amid opposition parties and lobby groups seeking a review of that decision. Zuma was granted parole on Sunday, 58 days after he was admitted as an inmate at the Estcourt Correctional Services facility in KwaZulu-Natal. Fraser has now admitted that after assessments, the Medical Parole Advisory Board did not approve medical parole because Zuma was in a stable condition. Let's stay with that story now and get some clarity on the powers of the Correctional Services Commissioner. We're joined now by legal expert Mpumelelo Zikalala via our video link. Mr. Zikalala, it's great to have you with us this morning on the show. And I suppose the question is the issue whether the former president is indeed terminally ill and not whether Fraser indeed has the powers to veto this decision by the Medical Advisory Parole Board?
That's correct. What you must also remember is that whenever a public administration or anybody in a public position takes a decision, it has to be in line with the applicable provisions of the Constitution. Firstly, it must be lawful. There must be some provision or legislative provision that allows you to take the decision. Once you have taken it, you have to prove that the decision was reasonable and that led to procedurally fair. If all those three things have failed, then it means you have taken an administrative decision which is not in line with our laws and it should be withdrawn and it is in fact unlawful.
Okay, so let's hone in on the one thing that you've just said there now. So three sort of provisos of this decision being sound, one of them that the decision was reasonable. Can that be the case on the face of it, just given the facts that we have before us, given that a medical team, an assessment by a medical team already found that the former president was stable and did not qualify for medical parole?
In fact, it goes to the core of the whole issue. Let's remember, we are dealing with medical parole, so you are going to be let go or being sent home on parole based on no medical reasons.
Right.
If it comes back as you are fine, there's nothing wrong with you, then there's no basis of you being released on parole. So on that alone, if the reports are actually true, it means that the decision was taken unlawfully and in fact should be revoked.
So I mean, Arthur Fraser going on to the state broadcaster just last night, saying that he said it in so many words, that he vetoed the recommendation that was made by the Medical Parole Advisory Board.
Maybe just to be fair on him, he would have to sort of explain as to what powers did he have to do that, what reasoning did he have to do it, what information did he have in which he's going to say, I'm going to veto the decision of professionals trained in this particular field to deal with this particular subject matter. I'm going to be on my own without any qualifications whatsoever to dispute what they've written and veto it. So he needs to explain as to the reasoning behind his vetoing and also an enabling provision that allow them to do that. If he can find those 2 points, then the decision could be one which is correct. However, if he can't, then it means he was incorrect in the manner in which he handled the matter.
So on the face of it, there are grounds to take this decision to court?
Yes, there are grounds, but what I might add on that is that the time in which it will take once this particular process has been done away with, let's say resolved, is too long. Give it plus minus 24 months to 36 months from the start up until the end. And by that time, the 15 months, which is the period attached to the former president, would have lapsed. Let's remember that by the end of October, normal parole would have applied. So in any case, the former president was only bumped up to getting parole by a few weeks. So the matter would have bolted by the time this whole process has been resolved. Yeah. Maybe the litigants in this matter could then say, we want to, on a matter of principle, to go to court, have all these issues dealt with by the court so that we have precedent that if a similar matter takes place on the next occasion, it would be easy for us to reference and have proper case law that determines how we handle these type of matters going forward.
Can you just, for the sake of our viewers, give us an outline of what it means to qualify for medical parole in our country under the Correctional Services Act?
Okay. Now, let's separate it into two. Let's take it or put it as a normal parole, where through the lapse of time, depending on the sentence that you are given, either you've served 1/3 or 1/6 of your period, you are then eligible for parole automatically. But then you have to provide, or the Correctional Services officials have to provide a report to the parole board and say to them, this person has been in prison for such a long time. He has complied with all the internal processes that we have. He has attended workshops. He has shown us that he is remorseful. He has shown us that he's fully participating in all the workshops that we have. We are true, or we are of the opinion that we have corrected their conduct and they are ready to go out there into the public. However, these are the conditions that one may apply to make sure that they're able to live a normal life, or that element of punishment is still there and the monitoring is still there. And then on the second hand, you have the one which deals with medical parole. Now, in which you are then saying this person or this prisoner is terminally ill. Now, that particular process has been explained, or its explanation or definition has been expanded. So it is much more wider to say you are terminally ill. We can no longer take care of you with the resources that we have inside our prisons. And we see that it is for your best interest and also for your quality of life that you are taken care of at home. At home, we know that you are going to have your doctors or traditional healers and any other intervention that you want to bring, including religious leaders, by the way. So that at the end of the day, the quality of life towards the end stages of your life is at least improved, or it is comfortable enough so that when the come times for you to pass on, you pass on in a respectable manner. Mm-hmm. So that's the medical parole that one has to rely on. But what you must note on both these two, it is highly dependent on expert evidence who are going to sit down, assess your nature of the conduct or the status of your health, and then make that recommendation to the parole board.
So really from what you're saying, it's the issues here are twofold. It's the issue of whether the former president is, according to what you've just said, is indeed terminally ill, and whether Arthur Fraser has the powers and can back up the decision that he's made to veto this decision by the Medical Advisory Board.
Yeah, definitely. Let's remember the three pillars that we are dealing with must be lawful, reasonable, and procedurally fair. Did we have the reasonableness, the reasons which are sufficient to say that someone must be released on medical parole based on the medical assessment? Do we have the legal structure that allows Mr. Fraser to veto the decision of the medical parole or the medical practitioners? Mm-hmm. And was the procedure followed to the T? If all those boxes are ticked, then everything is fine. Yeah. If one of them is missing, that means that particular decision is unlawful.
I suppose the question now is it worth to take it up on appeal, so to speak, to take it to the country's courts, just given, as you say, that he would have been eligible for parole anyway by the end of October, and his term is also just a 5-month sentence. Mpumelelo Zikalala, let me thank you for your time this morning. Thanks so much for unpacking the story, giving us a better sense of how to understand it.